paradise, put up a parking lot with a pink hotel, a boutique, and a swinging hot spot. Don't it always seem to go that you don't know what you've got till it's gone? It pays paradise, put up a parking lot.
All right, folks, welcome back. In our first video on Kelo versus New London, I took a look at the arguments that Justice Stevens and others might make for the city of New London in that case. Now I'm going to take a look at the arguments that folks would make for Mrs. Kelo, or in other words, against the decision that the court reached, the decision written by Justice Stevens. As we saw in the last video, the expansion of the meaning of the term public use, as that's used in the Fifth Amendment, had been in motion for decades, really, with the court giving more and more deference to the legislature while including more and more under that umbrella of public use. However, the ruling in Kelo takes it really two steps further than any Supreme Court had done before. So one of the legal issues for the dissenters in this case is whether economic development is indeed a public use, or whether blight is required to declare a taking to be a public use. And you'll see that that sort of combines two legal issues together from our first video. And the second thing that they took up is that the deference to the legislature, which Justice Stevens showed, was unnecessary and incorrect in this case because strict scrutiny should have been applied instead. So we're going to see both of those issues in this video. Let's start with the first one, blight, economic development, and public use. The opponents of the Kelo decision asked whether economic development constituted a public use under the Fifth Amendment. One of the largest impacts of this case was the expansion of that public use phrase to mean, as Justice Stevens declared, public purpose, while looking to Berman and to Midkiff as precedent for doing that. So what arguments did the dissenting justices give against what Stevens had done? Well, we're going to focus on O'Connor. First, Justice O'Connor argued that the state cannot usually take from A to give to B. This would be a purely private transfer, as she calls it. She argued that there are two things that you look for in any sort of, quote, public use taking. First, a transfer of private property to public ownership. So for instance, imagine a military base. And then second, you could allow a transfer of private property, she says, to private ownership where the public is allowed access to that property. So for instance, the land or the services in question are actually open to the public to use, and she calls this the common carrier exception. So think of a railroad or a public utility, which is a common carrier of our freight and passengers, a common carrier of our telephone calls. And if they have to effect a taking in order to build those railroad tracks or put those telephone poles up, perhaps the court would allow that as an exception. Of course, it's easy to see that the Kelo case couldn't be classified as a public ownership case, but it's not a common carrier case either. Not all of the lands seized are going to be open to the public, and not all of the services will be available to them in some sort of public way. So admittedly, the city isn't taking from Mrs. Kelo and giving directly to Pfizer, but they are taking from her to give to some other private party. The public may be able to visit the restaurants that might open because of this plan, but the Pfizer lab itself, of course, won't be available to them, and neither will the research and development or training centers that are built in the office parks. So O'Connor's question becomes, would these transfers of private property into other private hands be permissible? O'Connor did admit that Berman and Midkiff, a decision she had actually written, Hawaii versus Midkiff, she did admit that they allowed takings where a public purpose exists, despite the fact that there was a transfer of private land to a private party for subsequent private use. But she said that this was only because the, quote, extraordinary pre-condemnation use of the targeted property, Mr. Berman's property, or the oligopolist's property in Hawaii, she said that use inflicted affirmative harm on society, in Berman through blight, and in Midkiff through oligopoly. You can find that quote in part 2 of her dissent. So the public purpose in both cases was the fact that the harmful use of property was directly eliminated by the taking itself. This wasn't the case in Kelo, she said. There was no affirmative social harm being caused by the properties, and there was certainly no blight. Although the property in question in Berman was also not blighted, as we saw, there was a larger issue of blight overall in the area that the property was located in, and that larger issue of blight overall would be alleviated by the complete revitalization of the area in accordance with the overall comprehensive plan that the District of Columbia had developed. In Kelo, she says, there wasn't a similar blight issue. And in fact, she said instead that there were other social problems present in the town, such as low employment. So it wasn't the houses that were causing this. It wasn't blighted pieces of property either that were causing this. Instead, it was other social problems. So again, the Berman case, she says, is just not analogous. So you see her here using a type of reasoning that I've recommended to you before. She's trying to say, by analogy, whether this case, Kelo, is like cases that have been decided before. And she's got another little issue that she has to solve there, which is that she wrote the Midkiff decision. So she's going to need to differentiate it from the Kelo decision in order to come up with different decisions in the two of them. And there are other analogies you could look at too. 82-year-old Mrs. Derry spent her whole life in her house. She wasn't running a brothel or a seedy motel that attracted drug dealers, other cases that have been addressed by courts in other circumstances. Mrs. Kelo, for instance, didn't spend her days in her little pink house manufacturing bricks, breaking the law in a residential area, yet another case that the court has actually dealt with. So O'Connor argued that the takings in this case, therefore, do not directly alleviate the existing blight conditions because it's not the properties themselves that are problematic. She suggests that it's just not really the place of the state to determine how one should best use their home, for instance, economically. And she shudders at the thought that, quote, all private property is now vulnerable to being taken and transferred to another private owner, so long as it might be upgraded. That's in the second paragraph of her dissent. But keep in mind a really important qualification here. This does not apply for her in cases of blight, because then she would in fact allow the state to take property for economic reasons. So she's got a hard argument on her hands. She has to show that she can approve of what was done in Berman and in Midkiff, but not what was done in Kelo. So a lot of students in the past have latched on to O'Connor and said, look, she's the champion of no government taking ever, or she's the champion of no government economic development taking ever. A smaller principle, but a firm one nevertheless. But neither of those is actually what she said. She has a difficult argument to make in front of her. She's got to say how Berman and Midkiff were correctly decided, allowing certain economic development takings in those instances, but that Kelo was incorrectly decided. Justice Thomas, in his dissent, states another worry. He worries actually that the Kelo decision would allow cities to force low-income and often Black families to vacate their homes in order to build luxury condominiums, or maybe to close every mom and pop store in a neighborhood to instead open up a Whole Foods. But here's what's really important to note. Under something like Justice O'Connor's blight rule, which did allow some economic development takings, that was already happening, as Justice Thomas admits in his dissent. It's always the low-income neighborhoods that are called the worst and blighted, and racialized terms are used like ghettos. Could Justice O'Connor's rule really save us from that? And this is going to bring us to the second legal issue that the opponents of the Kelo decision had. That's the issue of deference by the court to the legislatures. The Kelo ruling you've seen shows fairly extreme deference to the legislature on the matter of what's considered a public use. As I mentioned earlier, the court has historically granted deference to local governments in defining what its communities need. And moreover, the court has interpreted the term public use really broadly. For instance, we saw that public use doesn't necessarily mean publicly occupied, even for Justice O'Connor. But despite a long history of deference, Justice O'Connor argues that the court shouldn't have deferred in this particular case. If it's left wholly up to the legislature to define what public use is, then she suggests there's really no check left on the tyranny of the majority. Justice Thomas, in his dissent, also criticizes deference, at least when defining a fundamental right enumerated in the Bill of Rights. If the courts aren't going to interpret fundamental rights and constitutional concepts, then why have judicial review, he asks. And for the purposes of this course, you might actually be asking yourself that question. Yeah, why have judicial review? Justice Thomas then also complains that the wrong standard of review was used in deciding the Kelo case. He says that the court used rational basis review, and we know from our previous lectures that that's the minimum level of review. It only requires that laws be rationally related to a legitimate government purpose, or similar phrases like that we've seen in some of our cases. He says they should have instead used strict scrutiny, the highest level of review. And that's triggered when government infringes on fundamental rights. Strict scrutiny review places the burden on the government to show that the law is narrowly tailored to achieve the desired purpose by the least restrictive or least discriminatory means, and to show that the law is substantially related to at least an important, perhaps even a compelling government purpose. And again, we've seen phrases like that in many of our cases. So if strict scrutiny had been applied, Justice Thomas suggests, the court would have found that the arguments of the city just didn't pass muster. Even if it were found that the function of government is to ensure economic prosperity, the plan, he says, is neither narrowly tailored, nor does it actually achieve the goal of the city by the least restrictive means. There are, for instance, other ways that the city could have attracted jobs or brought commerce without using that specific parcel of land on which Mrs. Kelo had her little pink house. The city could, for instance, have used tax incentives, or it could have used other lands or something like that. In other words, it didn't use the least restrictive means. And moreover, Thomas says, the public benefits in question weren't guaranteed. And so there was no, what he calls, essential rational nexus between the regulation and the impact that it was supposed to have. And neither, he says, is the action guaranteed to substantially advance the state's interest. Therefore, he suggests, had the court applied strict scrutiny, they likely would not have deferred to the legislature and would have protected the fundamental property right over this potential for new economic development. Now, even some of the justices who agreed with Stevens's final decision for the city of New London, even some of them had to concede some of the points that Thomas made. Kennedy, for instance, agreed in his concurrence that any benefits to the public from this taking were purely speculative and sort of had to be. And he said that private benefits with only, quote, incidental public benefits do require stricter scrutiny, but he simply declared that this wasn't the case in Kelo. New London pointed to more than incidental public benefits. And let's add on one more thing that the dissenters disagree with the majority about. They point to the end results, and they say, look, the proof is in the pudding. When courts defer to legislative judgments, that just enables bad judgments. So exactly how well did the redevelopment plan turn out for New London and for Pfizer? Well, actually, following the decision, the redevelopment plan was eventually abandoned. Neither jobs nor prosperity made it to the city of New London. And after a certain time period, Pfizer even closed its plant. The thing is, the same had happened in the Berman decision. Washington, D.C. had abandoned that redevelopment plan as well. And you can actually take a look at Mrs. Kelo's house, or the place where her house used to be, on Google Maps today. The lots all around are empty, and the house now sits there vacant. So to anyone who would rely on Locke's definition of waste, well, after Kelo, the Fort Trumbull area, and remember, after Berman, the Southwest DC area, both became genuine wastelands. Now, no one expects that the court can actually predict the future or know for sure whether a proposed legislation or redevelopment plan really will be successful. The court sort of walks a fine line here between constitutional rights and economic development. But opponents of the Kelo decision say that it should have been able to learn from its past decisions, from the consequences of its past rulings, and it should have held cities to a higher standard of proof in this decision. So I look forward to discussing the Kelo decision with you when we get together in class, but do not forget to watch the final video in this series, because our test case is actually going to be about something called a regulatory taking.